Good afternoon, everyone. My name is Dylan Minch, and I am the Legal Representation Director with the Texas Children's Commission. And on behalf of the Children's Commission, I would like to welcome everyone today to today's webinar that's entitled Mediation in Child Welfare Cases, Preparing, Participating, and Proposing Solution. This presentation will be provided by Michelle Morgan of Morgan Law, Sean P. Healy of Healy Law, and Sonja Sims of Sims and PuPurzer, and will focus on the benefits of mediation in child welfare cases. A copy of the PowerPoint presentation, along with any other additional materials by the presenters, will be made available for download on the Children's Commission On Demand and MCLE webpage. For those of you who are watching the presentation live, the Q&A feature is enabled, so feel free to submit questions through that function, and they will be answered at the end of the presentation if we have additional time. The MCLE course number will also be provided at the end of the presentation. If you happen to be watching this webinar on replay, you can email the CCC training@txcourts.gov for MCLE self-reporting information. And it is now my pleasure to turn it over to our presenters and talk about the benefits of mediation. And the first thing I wanted to talk about is I know not every jurisdiction practices mediation and is familiar with mediation. So Sonja, I might start with you. Can you just give us an overview of what exactly mediation is and what makes it different than other negotiations or other types of settlement?
Sure. Yeah. Mediation is an informal process where the parties to a case come together to reach a binding, non-revocable agreement. So long as it is signed by all the parties to the case, you can be very creative in reaching an agreement that resolves the case in a way that best benefits the parties to that case. I think it's a little different from negotiation because in negotiation, there generally is not a binding agreement at the end of it, but the Family Code has put in place measures to say that a mediated settlement agreement is going to be binding and non-revocable so long as the mediator follows those steps.
Thank you, Sonja. Sean or Michelle, is there anything that stands out to you about mediation that makes it unique as a form of finding resolution in a case?
I think there's a lot of things, areas where it differs significantly from litigation. And the biggest one is control that the parties have that they don't have in the courtroom anymore. And a much broader information set that you can use. The rules of evidence are going to tie hands sometimes in litigation of what's even going to come in. And so the fact finder may not be able to consider all of the pieces to the puzzle to work out an agreement, but it leaves the parties in control instead of a third party. It leaves room for creativity. We still have to come up with agreements that are enforceable, that a judge can sign, and that aren't contrary to what the law says. But it does give a much bigger ability to account for those things and to really discover what's truly important to each individual party. And I think particularly when you're talking about child welfare cases, that can be a pretty wide range of things, and the ability to customize visitation plans, transition plans, what rights and duties are going to look like. That customization and creativity, I think, has a much better chance of, number one, having buy-in from all the parties and is more likely to work better going on down the road. But also, you can take the time in mediation to really customize plans in a way that the court really can't do, either because they don't have enough time, enough information, or because there's things that don't necessarily come in. And so I think it really gives an opportunity to do those different creative things and really focus on what's important to each party, because there are often times where what's important to one party is not as important to another party. And so it really does give room for people to get more of what they want instead of the absolutes that the court can do.
Thank you, Michelle. Sean, is there anything you wanted to add about what makes mediation unique?
Yes, I deal with pro se parties sometimes, and so I like to describe mediation as negotiation with a referee. I think both of them have the goal being reaching a resolution, so it's not just floundering around talking about people's feelings and stuff. There's actually a direction that you're trying to move in, and the mediator is the person who's supposed to take charge of that and drive the mediation toward its goal. And if a mediator becomes a student of negotiation and mediation, he or she can really develop some strong skills to settle these cases. And the policy allows the parties to override the judge's power. The only catch is they all have to have their autographs on the same piece of paper. In child welfare mediation, the great thing about this is it's a lot more difficult because it's multi-party mediation, but the mediator can rely on all the different parties and participants to represent different goals like child safety, best interests, parents' rights, the children and all that, and just solely focus on finding that zone where everybody can settle.
Thank you, Sean. And that leads us to sort of a perfect transition. Both you and Michelle touched on it a little bit about there are multi-parties in child welfare mediations. Who needs to be included at a mediation in order for it to be successful? Who needs to be there? And Michelle, I'll start with you on that question.
Okay. Well, certainly the department needs to be there with someone everybody needs to have somebody with decision-making authority. It's very frustrating in mediation when you go 4 or 5 hours and then you find out, oh, well, I have to run this up the flagpole. And then the person with authority is either not available or has not had the benefit of hearing all of the information back and forth. So it's important that each party has somebody with decision-making authority, but we're talking about CPS, or the department needs to be there with their lawyer. At least the attorney ad litem for the child. Often you're going to have a guardian ad litem or a CASA. Certainly each of the parents are important to be there. And then if you have any interveners, you might have interveners there. I think it's also important to note who should not be at mediation. And that's anybody who's not a party unless everyone has agreed in advance. If you're going to be talking about a custody arrangement, either with maybe a relative who's not a party or the foster parents or something like that, then the parties certainly can and should agree in advance that anybody who's going to be critical to coming up with agreements is going to be agreed upon to be present at mediation. But I think it really gets in the way of mediation when you have, for lack of a better word, what I call burning ears. And so maybe you have a placement that's really not going to be a part of the ultimate solution one way or the other, and doesn't need to be contributing to, well, these are visits I think I could deal with, and this is what my schedule looks like. Folks don't need to be there for just their own informational purposes. And I think that can be confusing for parties in particular. They do a lot as they come up to mediation, depending upon where in the case the mediation's happening, but particularly if it's happening at the end. They've been to a lot of social work kind of based processes, family group conferences, permanency conferences, staffings, where the more the merrier, and we invite anybody who might want to have any kind of input. And I think that folks don't always have the expectation, clients don't always have the expectation that mediation is going to be focused on the legal issues more than the social work kind of based issues, and is also really going to be limited to the parties and any critical players who are going to play an active part in the terms of any agreement going forward.
Thank you, Michelle. And you made a great point, which was kind of where I wanted to transition to next, is sometimes mediation can feel a little more informal and more like a social work process, but it is a legal process that's geared towards creating a definitive legal outcome. And I might just open up to any of you who want to answer it, but why do you think it's so important for attorneys who are participating in mediation to be up to date on the latest appellate and legislative changes? Why is that a crucial thing for them to know in mediation? Sean, I might start with you on that one.
When I started mediating CPS cases, I knew a fair amount about mediation and I knew a fair amount about family law. I didn't know nearly as much about CPS cases as I do now. And over the years, I've gotten to see everybody's cards as the mediator. So they tell me what they plan to do if they go to trial. And many cases that are in litigation end up using results-oriented mediation, which means you compare the offer on the table to what they're likely to get if they go to trial. So that requires, for a mediator to be effective at that, the mediator has to know what the chances are at trial. So if the mediator's not intimately familiar with the different arguments that typically come up in court, the evidentiary issues, and then hopefully the tendencies of the judge and the jury and things like that, the latest case law, some of the typical limitations that you have with CPS cases, they're not going to have the credibility or the ability to weigh the chances of going to trial. So they're not going to be able to settle the case.
That's a great answer. Sean, Sonja, or Michelle, do you have anything to add?
I think I would just add that, a mediator's job is not to give legal advice, but we are facilitating communication. And so being up to date on the latest case law allows us to facilitate communication, to get the parties to talk about what their options are and discuss the outcomes that they would like to see happen.
I think there's, in addition to that, to kind of touch on what Sonja said, a lot of the mediator's job also includes reality testing. And if you don't know and you can't say to the attorney, how are you going to get this evidence in? How are you going to deal with this evidence that you know is going to come in? Because quite frankly, if you can't convince the attorney that they need to at least consider the offer, they're not going to convince their client. You can convince the client and their attorney is going to tell them not to do it or not to agree to it. So it's important for the mediator to know all of those things as well, for both the credibility in the room. I actually came the kind of opposite direction of Sean, as I did CPS litigation for a little over 10 years before I switched to CPS mediation. But you do have that credibility in the room, not only with the clients, so they feel like that you know what you're talking about. When you're talking about, these are some things you need to expect about might come in court if there's no agreement today, not in the way of a threat, but just so they can evaluate what is my best option and do exactly what Sean said, which is, okay, what do I think my worst case scenario in court is? What do I think my best case scenario is? Where is my risk amelioration? Am I willing to risk the potential worst outcome to get something that I want today? Or can I live with some of what is being offered today? I think sometimes the best mediated settlement agreements are the ones where nobody leaves fully happy, because it really has been a meeting of the minds and everybody's come together to try to meet some of the needs of all of the folks involved. And if the attorneys are not up to date, not only on what the law says and why a particular ground might be more dangerous for their client, or what the grounds that they might face in a termination case, if that's what's going to be before the court or the jury, then it makes it difficult for the mediator to have credibility with both the lawyers and with the clients, and to do that reality testing. Are you really going to get this in court? Or how are you going to deal with this? Or what is a jury in your county going to say when they hear these kinds of facts? And so I think that's important. And I think it's important for the attorneys not only to be aware of what's going on in the law these days, and there have been a lot of changes, probably more. I've been doing child welfare law for nearly 30 years, and there have been more changes in the last 5 years than I think in the previous 25 combined. If the attorneys don't know what their risk is and what their client's risk in court, and more importantly, if they don't know the facts of their case and they're not up to date on that, it makes it very difficult for them to advise their clients. And if they haven't advised their clients before you ever come in the door, then it's a really far road for the mediator to get a client to travel from, oh yeah, everything's going great, I'm getting my kid back, to CPS is asking you to consider giving your children up for adoption. And so if the attorney has not done that preparation work with their client throughout the case, it makes the mediator's job a lot harder, and the chances of being successful and getting a good outcome for your client go down.
Michelle, that's a perfect transition to our next topic that I want to discuss, which is, when is mediation appropriate in a child welfare case? Sonja, do you have thoughts on that, of when mediation is appropriate? When does it usually occur, and when do you find it to be most fruitful to occur?
So it definitely is most fruitful when the parties are going to actually show up. If you have a missing father that has not appeared in a case, or an unknown father, you need someone there with decision-making authority. If you can't get the parties to the mediation, it's not going to be helpful. However, in most cases, the parties are involved and engaging in services. And so there are several points throughout the case that mediation could be valuable. For example, mediating before the 262 hearing. You can mediate service plans or safety plans, visitation. Sometimes we also mediate kind of mid-case, like at the first permanency review before final order, to begin discussing what the permanency outcomes are, or the possibility of extending the case to get more time to try to reach reunification. I think that people should be more open-minded about holding mediations at multiple points throughout the life of a CPS case.
Thank you, Sonja. Michelle or Sean, is there anything you wanted to add about when mediation occurs, or a particular time in the case where you think mediation can be beneficial?
I think
I wanted to comment. Sorry, go ahead, Sean.
Sean, I'll go with you, and then we'll come back to you, Michelle.
Okay. There are a couple of factors. I think you have maybe one and sometimes two shots at mediation in each case. So I like to mediate when the chances are maximized. If you start out around the pre-adversary period of it, the case hasn't advanced far enough to where you really know how it's likely to come out. So it's really hard to mediate the entire case at that point. And also, the parties have not gotten fatigued and tired of court and wanting a solution yet. So if you go to the eve of trial, you have deadlines, you already have information about whether the parents have completed their plans, where the case stands, where the department wants to go, and everybody feels confident that they have the information. So the mediator has the most cards in hand at that point. But sometimes you can go back a little bit from that and get a case settled a little bit earlier on. If you mediate on the eve of trial and you reach an impasse, that if it's right on the eve of trial and there's no extension available, then you've eliminated the chance of recessing and then coming back at a later point once questions are answered or once everybody's had time to think about it and really decided they want to settle. So I just like to do it based on when the chances are best with that individual case. A lot of times that's closer to trial than it is to the beginning in my experience.
Thank you, Sean. Michelle, did you have something you wanted to add?
Yeah, I would just say a couple things about that. I agree with Sean. There has to be some immediacy. And so sometimes the time not to do it is when you're pretty far into the case, but it's not going well and it looks like it's headed for trial. But if you're still 2 months, 3 months out from trial, you get a lot of, well, I'm going to do the services now. And that immediacy of, okay, the time to do the services is gone. And this is the boat that you're in. And we have to focus on the boat that you are in today, not the boat that you want to be in or feel like you should be in. This is the boat you are in today when you're staring down a trial coming up pretty quickly. But I think really depending upon the timing of when you're doing it might also adjust the focus. So I think those early pre-262 mediations, which is honestly not something they do in my jurisdiction yet. But as I've participated in this commission some, I can see how the immediacy there, I think the immediacy has to be there for agreements to be in general, but I think the immediacy in the pre-adversary point can be the immediacy to maybe avoid the case, or maybe the immediacy to get a relative placement. From an attorney standpoint, if I think it's going to go the TMC route and there's nothing I'm going to be able to do as an attorney representing a parent to prevent that, or even representing a child who doesn't want to be in care, then the immediacy might be, let's get every single service identified and let's custom tailor this service plan instead of here's our cookie cutter. Okay, psychological, individual therapy, parenting classes, drug testing, any of those that may or may not apply in any of your cases. And a lot of them will, but occasionally they won't. Occasionally there may also be another thing. Do we have some cognitive deficits in one of these parents? Do we have a medical issue that's going to require some additional training that we can get earlier, or some kind of developmental disability that we need to identify those resources much earlier in the case? Because when you don't identify those needs for additional services until 7-8 months in the case, it's often too late. And so I think trying to find the immediacy for whatever stage you're in is going to be very important to kind of coming up with an agreement. But I do think you can find that immediacy at different points in the case based on what the focus of the purpose of mediation is.
Michelle, that's an excellent point. Sonja, as someone who has done some of those mediations, is there anything you want to do to flesh out of when that sort of immediacy can be different depending on what the goal of the mediation is and what the stage of the case is?
I agree. It's going to be very fact specific. And one of the benefits in my jurisdictions, we do some pre-262 mediations. It's exactly that, to avoid the case, maybe find a safety plan, maybe transfer conservatorship to a relative who will be safe and appropriate, avoid the necessity of a CPS case altogether, or negotiate how it's going to proceed. So it is definitely fact specific to find when the best time to go to mediation would be.
Thank you. So I wanted to focus a little bit now on why participate in mediation, particularly for those who may be new to mediation or for jurisdictions who are considering implementing a mediation program. Why is mediation so important? What opportunity does it give the parties in the case that is unique? And Michelle, I'll start with you.
Well, for starters, it's required in most cases before you're going to have a trial. So sometimes people come in thinking, well, we're just punching our mediation stamp. And sure enough, you get it done if you just can get people talking and engaged. And sometimes you have to back away from the bigger elements in the case to kind of just develop a little bit of rapport and let people kind of slowly kind of walk down the road. So number one, it's often required before you can have a trial. So that's one reason. The other is we've already touched on very briefly the creativity, because you can really account and very much customize to this particular family in this particular case that is much more difficult in the courtroom. I think it's binding on the court. Sonja already pointed on that. If every party has signed it, then there's very little wiggle room for the court not to enter that agreement. But quite frankly, not only can it be valuable when everybody gets on the same page and signs on the dotted line, it can be partial agreements can be very valuable. You can have partial agreements that the parties might agree on. For example, they might agree on conservatorship. They might agree on child support. They might agree on, but not on the possession and access. They might agree on all of those, but not child support. So you can really narrow the things down that you need the court to make decisions about, and just agree, instead of having a 3-day trial or a week-long jury trial, we're going to agree that we're going to have a 3-hour hearing in front of our, regular judge that we see all the time, instead of maybe our trial court judge, which is again going to vary based on your county, whether it's your same judge start to finish or somebody different. But narrowing the issues is a good use of the court's time and the court's resources in terms of paying attorneys and clients paying their attorneys as well. And sometimes you'll have a situation that Sonja referenced where maybe one parent has not, for whatever reason, either chosen to or been able to actively participate in the case. You might be able to get all of the rest of the parties on the same page and write an agreement that looks something along the lines of, hey, we're going to seek an order that has these conditions. And then you add a paragraph that says, and we're going to request these provisions about this other person from the court, because they're not there to sign on to it. So it can't necessarily be the body of the agreement itself, but there can be an agreement among the parties who are there to say, and this is the relief we're going to seek when we go on this other party that's not participated. So any of those partial agreements can very much be beneficial if you're not able to resolve all of the issues in the case.
I think you made some really great points. And Sean or Sonja, can you think of any examples of that sort of creativity that Michelle talked about, where you were able to reach a resolution that really would not have been able to be possible at trial? And anything stand out to you in either one of you in that regard?
I really think just allowing the parties to express themselves. In mediation, we have a lot more time to allow them to have their say, what their frustrations were with the case, where they want to see things go. They kind of get to let off some of those emotions that you're not really able to do in court, and then come back to look at the facts and discuss rationally with the attorneys and the mediator about how they'd like to see the case resolved. So that is a big benefit of mediation.
That's an excellent point, Sonja. That ability to really be heard, to really express yourself, to have somebody listen to you, is unique to mediation. I also wanted to focus a little bit, and Sean, I go to you with this, because you talked a lot about sort of the power of the binding nature of mediation, that once everybody reaches an agreement, it's binding and effectively sort of ties the hands of the judge. And I wonder, how does that empowerment, how does that sometimes play with some parties in the case who might otherwise feel sort of powerless and feel like they don't have a lot of control? How does that play into that binding nature? How does that play into how they participate and feel in mediation?
Well, several things. First of all, the fundamental principle that underlies every part of the family code is the best interest of the children. And going in and having a brief trial with the judge where the information available to him is constrained by time limits and the rules of evidence, and then having him make a decision doesn't always produce results that are in the best interest of the children. In mediation, you're not constrained by the rules of evidence. People can say whatever they want to. They can bring in concerns that the judge either would never hear or probably would not take into consideration. So I think mediation is a lot more flexible, and the recognition, the policy reason why the participants are actually allowed to override the judge is because it recognizes that with all those different parties in there, everybody cancels out, they all do their job, and then the result is supposed to move toward the best interest. So you have CPS looking out for safety, CASA looking out for best interest, the parents looking out for their own rights and their contact with the children, the children's attorney theoretically doing what the children want, the guardian ad litem theoretically doing what's best for the children, and the mediator, all the mediator has to do is try to find a settlement. But with all those considerations, mediation is binding because those cancel out and forces a result that fits all that. Another consideration that's really important in CPS cases is people's dignity. Sometimes these parents, they may have made a lot of mistakes, but they still have some dignity. They care about their kids, and they come in with the belief that they need to be involved in their kids' lives to make sure to protect best interest. And sometimes that's not the case. And you actually see somebody who's made every mistake that a parent can make, making the ultimate sacrifice by giving up their children. So if you recognize that people need to be treated with dignity and they need to be allowed to have their day in court in a way that's not confrontational, not adversarial, and actually lets them say what they want to say, I think it gives them closure, and it also encourages them to think about what's in the best interest of the children if it's done right.
Yeah, I thank you so much, Sean, because I think that power of listening and that power of feeling heard is something that is really unique to mediation. That's just, it's very different than the courtroom experience for clients. So the next thing that I wanted to transition to talk about is what can people expect at mediation, particularly for those who are new to it. What should they expect when they go to mediation? And Michelle, I might start with you.
Okay. So I think obviously part of that's going to depend whether it's a virtual mediation or whether it's in person. But in general, you can expect that it varies from mediator to mediator, particularly virtually, though. I'm going to separate folks kind of as they come in into individual separate caucus rooms, both as a lawyer myself, but just in general in mediation too. I've found over the years that in a big group, even when everybody's in a cooperative kind of spirit and everybody's trying to do that, you either have people who are nervous to say something that's going to hurt their case, they're intimidated by the number of people, or it just feels it goes exactly against that control and power piece that Sean was just talking about, because it can feel very much like it's 8 people in the room against the parents. And it kind of sets up a dynamic that makes it very difficult and doesn't make them feel heard or that they have any power and control left in the situation whatsoever. So you can expect that in a CPS mediation in particular, you're probably going to spend a lot of time in separate caucus rooms. It may very well be that you have maybe the attorney ad litem in the department and CASA, if they're involved, or a guardian ad litem in one room. It may also be that they don't all agree what ought to happen, and so there's further separations. It's not uncommon to see those rooms change up during the day, but you can expect to kind of start off in separate rooms. The mediator is then going to give an opening introduction to all of the parties to kind of lay the groundwork for what to expect, but also kind of the basic ground rules for mediation. At the very minimum, your clients and you guys should hear at every single mediation that it's a voluntary process, that the mediator is not going to decide at the end of the day. And that sometimes can disarm people who are very, very nervous, and you can see that they're nervous, and you can kind of emphasize that to a client saying, look, there's nothing that's going to happen here today that you don't agree to. This is a voluntary process. You need to set the groundwork, especially since most of the mediators, I think, around the state that do CPS mediations are lawyers, that even though you are a lawyer, you are not going to give legal advice because you don't represent anybody in the case. Especially when you have pro se clients, you have to be really clear as the mediator that you can give some information about what the law says, but you cannot give legal advice and advise them one way or the other what to do. And trial strategy, any of those kinds of things, you're not going to do because you're not their lawyer. The third one, and maybe the most important piece that needs to be in any introduction, is that the confidential nature of mediation. It's a confidential process, and they need to hear that every single time, even if it's caseworkers or lawyers that can do the spiel in their sleep. My practice is to do it in full every single time. So if I ever got called down the road to talk about a mediation that I won't remember, I can say 100% of the time, I told him it was confidential, and I told him there was going to be an exceptions for safety. So it's really important that the parties know that it's a confidential process, that confidentiality applies not only to the entire mediation, but to each of those individual rooms and smaller groups they may be in. And so they need to let me know if there's some things we talk about in the smaller group that they don't want me to share in the other rooms. I may ask that if I hear something, I'm like, I'm going to bet their lawyer doesn't want me to say that in the other room. And so I might say, can I say this? I might also come back and check if I haven't done that, but they need to know it's confidential as a process, a whole, and each individual room. And they need to know the exceptions to that confidentiality. And that's basically safety. If you hear that a child's being injured, then you are still required by law, like every other citizen, to report that. And you need to tell the clients up front that you will report it if you hear it. And then additionally, I always tell folks, if I hear a threat to another person, then I'm going to report that for that person's safety. And if I hear a threat to self-harm, I may also report that, because I want everybody in mediation to be safe. And so it's important that they understand also how important that confidentiality is, because as lawyers, if we can't absolutely rely on that confidentiality and what we talk about not coming into court, then it very quickly would become malpractice to encourage our clients to talk about all the different options openly and freely. You know, if I were to relinquish, what would you think about this? Or what might this other piece of it look like if I did that? So they need to hear that opening in all of the rooms with those three elements. It's voluntary, the mediator's not going to give legal advice, and it's confidential except for safety.
Michelle, I want to pause you right there really quick, because I think I want to take like the different perspective for just a second. We talked about people who may not be as familiar with mediation, but I know for some attorneys who are very familiar with mediation and they may have heard that a lot, sometimes that's something that they have a hard time sitting through. And I might ask, Sonja or Sean, do you have any perspective on why that introduction is so important, even for attorneys who may have heard it a million times?
I think it's critical because a lot of times you either have pro se parties or you have parties who were not properly prepared for mediation by their attorneys because their caseload is usually a lot higher. In my civil cases, in my family law cases, I send out a letter to my clients preparing them for mediation, and usually discuss it with them so they understand what to expect. But I want to make sure we all start from the same baseline here, because these parents are going to be making it's going to be a defining moment in their lives. And so they're going to make decisions in the course of 4 or 8 hours. That maybe things that cross their mind on their deathbed. And you want to start them off with enough information to know what's going to happen, to know what to focus on, to know what to expect, and to stay under control and make good decisions. So I always tell them, I like to use a comparison of buying a used car or buying a house, because everybody's gone through that. And so I explain that we're going to start out and there's going to be an offer made by one party, and then most likely there will be counter offers, and then those will hopefully converge. And I compare it to buying a used car. And then eventually you get to the point where you've reached an agreement. And in this case, the only difference is that you've purchased a settlement. And then I also want to tell them something that I think is at least as important as confidentiality, and that is the finality of a mediated settlement agreement. So I tell them that I'm only going to yell at them twice. The first one is when they sign my agreement to mediate, where at the end I tell them, if there's a mediated settlement agreement signed, it's not going to be subject to revocation. And then I tell them again the same thing at the end of the mediated settlement agreement, right above where they sign. And it's all caps and boldface and underline, which everybody knows in this day and age is yelling at somebody. This agreement is not subject to revocation. And then I sell that as an advantage, because if you make a deal to buy a car and the next day the dealer comes and gets it and says, I'm sorry, we sold this to somebody else, or you go back to the dealership and it's been sold, you're not going to be happy. So if you go through the emotional process of accepting some sort of a compromise or even relinquishing the rights towards your children, if somebody upends that and the next day you find out that closure that you thought you got is gone, you're going to be upset. So I like to get them ready so that they know, okay, here's the first offer. Let's evaluate it and figure out whether you're going to accept it or make a counter offer. And then when we get to the end, I like to already have them primed to know they need to go through the agreement and make sure everything's in it that's supposed to be there. And then if it is, read that last line and make sure they really want to sign it. And then if they do, sign it. And at that point, once we have everybody else's autographs, it'll be set in stone and the judge will not be able to overturn it.
Sonja, any thoughts that you want to share?
Yeah, I think another very important reason why mediators need to do this is, we're kind of the new person to the case. We're popping in just for this one mediation period. We have to build trust with the parties there. And not every client has the best relationship with their court-appointed or retained attorney. They may have been arguing throughout the case. I need to come in as the neutral, as mediator, establish trust immediately with the client, with the attorney, maybe help repair some of the broken trust between the attorney and the client. So I want them to know that what I say is what I do. This is going to be confidential. This is what's going to happen. This is what's going to happen at the end, so that at least they can know to trust and hopefully rely on me to help them reach an agreement.
Thank you, Sonja. I now want to talk a little bit about some special considerations for circumstances that are not in every CPS case, but they're quite common in CPS cases. And the first one, Michelle, I'll go to you with one, is for incarcerated parents. If you're mediating a case with an incarcerated parent or attorneys representing a client who's incarcerated, what are special considerations that they need to think about in terms of mediation?
Well, I think a lot of that depends whether you're doing Zoom or a hybrid or in person. I will say that incarcerated persons are probably the one of the major populations that have significantly been able to increase overall their participation in mediation by being a lot of the different facilities. And it depends on what facility they're in as to how much access they're going to give. But I regularly am able to have people be on all day long on Zoom, and they're able to have the benefit of their counsel ongoing instead of it being, okay, let me check on that, or y'all come up with what you think, and I got to go back to my client. But I think the special considerations, if your client is incarcerated or you think is going to be incarcerated still at the time of mediation, number one, be in touch with the facility well in advance to figure out what access is your client going to have. Not only access to participate in the mediation, is it going to be phone? Is it going to be periodic phone calls that you can call your client every hour? Is it going to be 1 or 2 phone calls that you set at particular times? And if so, set them, get permission from the warden. Are they going to be available on Zoom? And so you need to know that. You also need to at least have an eye towards, if we do reach an agreement, what are going to be my options to get a signature? Some facilities are really good about the mediator emailing it to them. They have the client sign it and they scan it back, and then I'll make a DocuSign from that original. Sometimes it's going to be snail mail. Sometimes it's going to be the attorney getting permission from the court to drive out to that facility to get a signature. So kind of figure out as an attorney, what are the logistics of my client participating and also facilitating signatures. And quite frankly, as the mediator, it is highly unlikely I'm going to know that your client is incarcerated or needs an interpreter or a lot of these things that we're talking about. If you know that's an issue in your case as an attorney, let the mediator know. So we can, maybe the mediator's got some experience with one of these facilities or has dealt with this in the past and can raise some of those issues. But, I'm going to get a court report maybe that might be a week old and it might be 6 months old. And I'm going to get a list of people to send the invitation out to. I don't have information about some of those dynamics. I can make some guesses, like if I get a case and every single attorney on it is somebody I know because it's a systemic docket with the same folks, is on the Spanish speaking list, then I can at least say, hey, do we need a translator? Do we need an interpreter here? And do we have that arranged in advance? But with the incarcerated folks in particular, I think it's what is going to be the access during mediation. And if you're not going to have access, go see them beforehand with the entire range of all the things that could come up at mediation. So you have really good direction, and then see what you can do behind the scenes to figure out how we're going to facilitate signatures if we're able to reach an agreement.
Thank you, Michelle. Sonja, I might go to you with another specific circumstance that often occurs in these cases, which is domestic violence. How does that impact conducting the mediation, and how should attorneys help prepare a mediator for a mediation that's going to have that component in it?
I definitely think that domestic violence relationships or situations in a case need to be brought to the mediator's attention in advance. For example, if it's a in-person mediation, we want to make sure that we have the parties segregated. We do not want the opportunity for the victim to be physically present with the perpetrator. Even if it's a Zoom mediation, if everyone's joining in the main room at first and then the mediator is moving them into their separate rooms, that still creates the possibility of a face-to-face, even though it's Zoom, contact and possible intimidation or emotional manipulation. So it's very important for the attorneys to give us feedback as to what the history of the case is, and if there is any potential, even alleged domestic violence that maybe hasn't gone to a full trial, there hasn't been an arrest. Just the threat of possible intimidation or domestic violence should be brought to the mediator's attention so that they can be sure to take measures to keep control.
Thank you, Sonja. Sean, do you have any thoughts on any other sort of special issues that arise that make mediation more complicated? We talked a little bit about incarcerated parents, domestic violence, translator issues. Are there any other issues you can think of that make mediation more challenging or need to be considered?
Well, I'm about to commit heresy in child welfare mediations, but I always like to try to implore the attorneys to give me some information about the mediation ahead of time. I know we're all busy, but a lot of times, if the parties have not given me the rundown on what's happened, I spend the first part of the mediation finding out where we stand as opposed to trying to settle the case. So domestic violence is one issue that is obviously impactful on that. If we know that in advance, then my staff is trained on how to keep parties apart and put them in various places in my building to make sure they're safe and comfortable and everything. But in addition to that, I like to have people basically say, what was the reason for the removal? And so all the department has to do is click a couple times and send me the removal affidavit. Then I like to know what the status of the case is at that point. So if there's a permanency order or a CASA report that gives a snapshot, 6 months or so into the case, then I like to have that also. And I'll also like to have the parties tell me what the past offers have been, any negotiations and all that, so that I can know whose ball, where the ball is, whose court the ball is in on negotiations, and what they've already covered, and in general what direction they've discussed might be an option for settling the case. So they don't take that much time. I mean, I don't use a particular form because it always bothered me when somebody sent some PDF form that I'm supposed to fill in or a bunch of bullet points. I just ask them to give me the basics about the case so that I can hit the ground running.
Thank you, Sean. So the next thing I wanted to focus on is we talked, I think, a little bit about how the mediation process begins with that opening statement that lays those ground rules, that establishes that level of trust and neutrality. And then Sean, you sort of talked about people separating into caucuses and those offers going back and forth. What happens when you get to an impasse? If those back and forth offers sort of don't reach a productive fruit, what kind of tools do you use to get past an impasse? Michelle, I might start with you.
Well, I think there's a lot of things you can do. I think number one is just in general, be mindful to recognize your privilege. I'm a middle-aged white chick with a law degree whose parents are in their mid-80s and been married for 67 years. I don't have the same experience as a young parent, a person of color, struggling with poverty, things like that. And so I have to recognize my privilege in the room. But I think one of the first things that I try to do is acknowledge that they're saying no. This is not just, instead of making them feel like you're badgering them, well, what about this? And, I really think you need to think about that. I think the first thing you do is say, okay, I hear you loud and clear. This is not where you're going today, but hey, you're here anyway. One tool I use is, let's talk about trial prep. I hear you loud and clear. The answer is no, but hey, I'm booked for the whole day. Your lawyer's here, you're here. Let's take a little time to talk about what trial is going to look like, because as a human being and as an attorney and as a parent myself, I want everybody who comes through my office, and I tell people this, I want everybody who comes through my office to make whatever decision they're going to make today with full information, because I hate it myself when I make a decision and then find out, well, dang, if somebody would have told me that, I might have done something different, right? And so I'll spend some time. One tool that I use a lot, especially like, say, for example, a parent that's being asked to relinquish, they're not wanting to do it. My general assessment of the case after talking to everybody is that it's a pretty strong termination case, is I'll sit here and say, okay, let's talk about trial. Because I think a lot of times my own clients historically, and I think it happens in mediation as well, kind of have this, they sometimes, especially if the case hasn't gone well, tend to hyperfixate on maybe something the department did or didn't do. So I'm just using this example as kind of a tool I would use in terms of the trial prep. And so I'll go through, okay, first of all, these are the two things that CPS has to prove. They have to prove there's a ground, and they don't get to pick any ground they want, and they have to prove that it's in your child's best interest. Here's the burden of proof. It's not just, hey, did that kind of happen or not happen? Did they kind of do the services or not do the services? It's clear and convincing evidence. It's also not the same as beyond a reasonable doubt, because I think most lay people have heard that term, beyond a reasonable doubt. They've watched a lot of courtroom dramas, which I think tend to be heavy on the criminal side, and they don't realize that the burden of proof is a little bit lower here. And then I talk about who are the witnesses. I think a lot of people don't understand, at least in my jurisdiction, if they show up at trial, the first two witnesses are going to be the parents. And they don't really understand you're going to be on the stand and you have to answer all these questions, and they can ask you all kinds of things. And, the judge is going to be assessing not only your actual answers to those cases, but your demeanor. Because if you're screaming and yelling or losing your cool because the other attorney's purposely trying to push your buttons to show that you're volatile, the judge is going to notice that and think, wow, if I give this little 2-year-old toddler to this person who seems really volatile, is that going to be a safe thing that I want on my chest if I'm the fact finder? So talking about who are going to be the witnesses, talking about what offense reports are, I find a lot of times can kind of get folks who are thinking, no, I don't want to do that. If they want my rights, they can come and take them. But I think really just, and part of that is truly because I think it can get you past the impasse and make them really think, okay, maybe I do need to consider this offer, but also understanding and just empathizing. Look, these cases are not about whether you're a good person or a bad person, but the way trial is structured is it looks like let's spend a week to beat up on mom or beat up on dad, and it's a really painful experience. And I think people lose sight of the fact that it's not about what CPS did or didn't do for the most part, maybe a little bit changing because now they have a reasonable efforts prong, but it's about, is there a ground and is it in the child's best interest? And it's not about what's fair or how much you love your kids or any of the other, it's not your CASA's fault because they didn't drive you to the drug test. And it's not your lawyer's fault because they didn't do this, that, or the other. And so kind of just backing off and letting them hear you say, and again, to acknowledge, okay, I hear you. You do not have to sign this agreement. I told you that at the beginning, and I'm sticking to that. I acknowledge the no. And then really talk about trial, because that I have found is probably the most effective thing in getting an agreement going. And that works in both rooms. Sometimes you have to say to the department, are you really going to get that on these facts? Poverty is not a ground for termination. Is this a poverty issue or is this really a neglect issue?
Thank you, Michelle. I just want to make sure that I give Sonja and Sean a chance to weigh in if there's any other sort of impasse tools that you think are helpful or productive in these cases.
Yeah, I like to use the phrase "getting to know," because obviously the most famous book on negotiation is "Getting to Yes." I believe mediation begins when the mediator gets the first serious no, because up till that point you've been coasting, and now is when you earn your pay. So the Civil Practice and Remedies Code also governs this alternative dispute resolution, in addition to the provisions that are specific to the family law. And it says that the mediator can encourage and assist the parties, but not compel or coerce them. And I think that's where the line is. So what I want in my mediations, I don't want somebody who walks out being browbeaten to take a settlement, and then they're driving home, they're thinking, why did I agree to that? And then they're calling their lawyer the next morning asking how they can get out of it. I want somebody that wakes up and the sun shines and they remember that their case has been settled and it's just a matter of going and presenting it to the judge, and they know what their rights are from then on. So having said that, I think it's fair to give the parties a realistic expectation of what it's going to be like in court. And I like what Michelle said about doing trial prep and all that. Sometimes I'll even go to the point of doing a cross-examination on the party and asking them the questions that they're going to be asked at court to admit all the mistakes that they've made. And in this case, I've found a distinction that helps preserve people's dignity when you do this. I like the phrase, the evidence, it looks like the evidence is going to show blah, blah, blah. And then you can say, now, the judge isn't going to get the whole picture. Some evidence may be excluded, but what they're going to present is this. And so instead of saying you're a terrible parent and you neglected and abused your kids, you're saying the evidence is going to show that this happened and this happened and this happened, which is going to give a pretty strong impression that the kids were not, taken care of properly. It's kind of like the Southern expression, bless his heart. And then you can say the most horrible things about the person. I think in New York, they said with all due respect, and then you can just rip into somebody. But giving them a real taste of cross-examination can kind of give them some reality therapy there. So getting past the impasse, that goes into the creativity and the knowledge of how these cases work and how things are likely to play out at trial. So sometimes the mediator can play devil's advocate like that. I like to enlist the other parties, especially the amicus and the ad litem, to come in and talk to the parties, because they're not usually seen as being the enemy like the caseworker. So they can sometimes have more knowledge and more credibility, at least over time, than I've had to get the parties to do things. You can get creative. You can do a contingent settlement, like if somebody passes a home study, then the child gets placed here, or if the parent can accomplish these other 5 parts of their service plan by this date, then they don't get terminated or whatever. you can make a mediator's offer if the parties were converging, and then you have an idea about what might cut to the chase. There are a lot of things you can do. You can also appeal to what's best for the child, remind the parents or the parties what's best for the child, and tell them how good the situation is that they're in, if that's applicable, and ask them to make a sacrifice like that. So there's a lot of options, but it really, I think what matters is two things: determination by the mediator, and then knowledge and creativity by the mediator when you get to an impasse.
Sonja, is there anything else you wanted to add in terms of impasse tools?
Yeah, sometimes, bringing other parties in, the ad litem in to speak with the parents. Sometimes the parents need to hear from the family that is possibly being proposed as the permanent placement. If they're not a party to the case, the attorneys can ask the judge to order that family be allowed to participate in mediation, and sometimes just discussing how they're going to move forward as a family without CPS and CASA and everyone else's involvement is very hopeful to get over an impasse. I think something else I wanted to add from Sean earlier, information that the parties can give the mediator in advance to make sure that they are best able to avoid impasse. If there are intellectual issues or capacity issues, if you'd let the mediator know that in advance, because how I'm going to approach and communicate with someone who needs a little more time and attention is a lot different than how we're going to do a normal mediation with people who have been able to confer with their attorneys in advance. So even just knowing those things in advance allows me time to take the extra steps needed to prepare how I'm going to approach the case with the client.
Thank you, Sonja. Well, we're getting to the end of the webinar, and we're also getting to the end of the mediation process. So I wanted to talk a little bit about sort of what happens at the conclusion of the mediation. And Sean, I might start with you. Like, if there is a full agreement, what then happens at the end of mediation?
Usually as the mediator, I've encouraged the parties to keep notes, usually their attorneys to keep notes about where we are, because mediations, this isn't like a personal injury settlement or a child support settlement where there's one number that's going to be the settlement. Usually these things involve multiple provisions. What happens to parental rights? Who's going to be the conservator? What are the visitation rights? What about child support? What about back child support? And all that. What about supervision? So there are a bunch of details involved in the mediation, and it's easy to miss a detail. So normally I go away and I draft a mediated settlement agreement, and it never fails that the attorneys rip it to shreds or add new stuff or whatever, which is fine because it's the party's settlement. It's not my settlement. So they may come up with something different, or they may want to reword something. And over the years, I've come up with a standard mediated settlement agreement for several different areas that addresses some of those issues. But I go away and draft a mediated settlement agreement. Then I print out a bunch of copies of it and let the attorneys and parties go through it. And I have them write the changes down on the agreement. And then I put all those together and I take it around and make sure everybody agrees to those changes, and then go back up and make those changes and get it signed. And then sometimes the difficult part, if you're not all in person, is getting it signed. So we have a provision for using a remote signing thing like DocuSign. Adobe has one also to get signatures for people that are not there in person. There are other ways of doing that, but it's vitally important to strike while the iron's hot and try to get those signatures while everybody's still feeling positive toward a settlement. And then once you sign it, generally we file it with the court, and that's it.
Thank you, Sean. We'd have a question that came in, and I want to bring it up here just because I think it's particularly relevant to this discussion. And it is that someone asked, in their experience, each jurisdiction has templates for MSAs, but they're different. Sean, you mentioned that you have sort of a standard template that you use, and I wanted to ask Sonja or Michelle, like, because the MSAs can be very, very complicated, how do you approach that drafting of the MSA? Do you have a template? Do you recommend a template? How do you approach that issue?
Well, I do have a template. I mean, and a lot of times it just makes drafting faster. So, it's going to have the style of the case. It's going to say what date it was. It's going to say it's a mediated settlement agreement, and then the appearances section. And then it's also going to have kind of already on there, the yelling that Sean talked about, the in all bold, all capital underlined letters saying this agreement's not subject to revocation once signed, and with some signature blocks. And then I'm just going to find and replace like the names, which will catch the appearances and the signatures, and then the body of it. But I also have like commonly used templates. So if somebody's going to stipulate to say the O ground that they didn't complete their services, I have old MSAs I've done for that. It's a cut and paste, and it takes about 5 minutes to draft. If it's going to be a relinquishment, I have old ones that I use that I kind of keep up, that I keep in a separate file for general forms. The custody ones, even those, I mean, we do see a lot more customization there in terms of like the visitation plans, but even just the basic outlines of, they all already say that it's in the best interest. If it's going to be a final order, my template's going to have at the bottom of it a discovery waiver and a jury waiver, and I can take those out if we're agreeing to a temporary order instead of a final order, or a return and monitor and extension, or something that's not going to dispose of the case in its entirety. But yes, I have forms, and they're just ones I create over the years. I'm happy to share them and redact if there's other mediators that want to reach out by email.
Thank you. Michelle, Sonja, do you have any thoughts on that?
Yeah, I have the basic MSA form, I think, that most people have. You can get from TextDocs or State Bar Forms. But then I also have just a database of frequently used terms, for a stair-step increase to standard possession visitation schedule. It's 2, 4, 6 hours that I then have to edit for the specific facts of each case. But I do generally have that I can cut and paste into the MSA to save time during the mediation.
Thank you, Sonja. So we've talked a little bit about if we have a full conclusion at mediation. I now want to talk just a little bit about what happens if we have a partial agreement. So Sean, if a full agreement can't be reached, what kind of partial agreements can you make that are productive?
Well, the easiest one is you can get everybody to agree to come back to mediation, to recess it as opposed to doing an impasse, and then to come back again on the eve of trial. Sometimes you can add to that mediating the process. In civil cases, we mediate discovery deadlines and things like that. Sometimes we'll mediate the actual contents of discovery, what's produced and all that. In a CPS case, sometimes you can mediate the service plans, what the parents still have left to do. You can mediate consideration of relative placement. So you can say that CPS will do a home study on the maternal grandmother. And then sometimes you can even mediate, if it passes, they'll place the children with the maternal grandmother or whatever. And sometimes you can end up with a full settlement that takes care of all the possibilities. There's some contingencies that have to be fulfilled that determines whether there's a termination and a relinquishment, or a reunification or something like that. And I would caution everybody there. In some places, there's a common practice of having the parents go ahead and sign relinquishment affidavits and then holding them in trust. And then if they succeed with their plan, you shred them. And if they don't, you present them to the court. I don't think that it's truthful for a parent to sign that when they don't believe that termination is in the best interest of the children. So I don't think that an attorney can ask a litigant to sign something like that they don't believe, so that if something comes up later, it can be presented. I think you have to wait and have them sign it at the time, and then you put in the agreement, if you get to this point, that if they refuse to sign it, then the court can grant the termination based on a stipulation of best interest and grounds, and then the court can receive evidence on what grounds exist. So that has a hammer that encourages the parent to follow through with that part of the agreement if you get something like that done. But I've done those contingent agreements where basically you codify the service plan and make it a do or die type plan. And I've also done third party relative placements. I've done reunifications, stair steps, pretty much everything you could come up with.
Well, we're nearly out of time, but I did want to address very briefly what happens after mediation. We've talked about how binding it is. Are there any circumstances where a mediation settlement can be overturned, and what can possibly overturn them? And Sean, I might go back to you for that answer.
Okay. So everybody seems to believe that, number one, that everything said in mediation is confidential, and number two, that mediated settlement agreements are absolutely set in stone, and that's not the case. We've covered some of the exceptions to mediation confidentiality, but that wasn't your question, so I won't get into that. But you go back to the statute, and the statute says that it has to have the magic language of this agreement is not subject to revocation. You have to have signatures by all the parties and their attorneys if they're present. And pretty much once you have that, you've got an enforceable agreement. And then the In re Stephanie Lee case says that in general, a court cannot overturn an MSA that meets those requirements. Of course, that case has some dicta that presents some situations where the court might be able to overturn it or get around that, like by calling CPS and opening up another investigation or something like that. But generally speaking, if the statutory requirements have been met, the courts have been so jealous in making these agreements irrevocable, they won't even let the parties agree to revoke or modify them, which I think is crazy. But that's generally the requirement. And so, I mean, you need to sign these things with extreme caution because they're basically set in stone.
Thank you, Sean. We are over time, so unfortunately we don't have time for questions. We did answer live the one question that was submitted. But I want to really thank our presenters, Michelle Morgan, Sean, and Sonja. You did a wonderful job today. I'm so glad that you were able to share your time with us. On behalf of the children, I want to thank them and everyone who participated in this mediation today. If you do have any additional questions, you can email our presenters, and they're happy to try to answer any questions you might have. I hope that everyone will join us for our next webinar, which will be on September 20th, and it'll be focused on supporting school-aged children who are in CPS care. For those of you who may be watching this course on a replay, you'll need to email cctraining@txcourts.gov for the MCLE self-reporting information. And just once again, I really want to thank everyone who joined us in this presentation. I want to thank our presenters, and I hope everyone has a wonderful rest of your day. Thank you so much.